a rather bizarre move, the government has raised fresh demands on decade-old transactions done between 2013 to 2016 through Mauritius, Singapore and Cyprus. This is hugely surprising since it was assumed that the structures set up prior to 2017 were grandfathered and the risk of proving substance under GAAR, which is General Anti-Avoidance Rule, came only after 2017. Now that the assessments have been opened up against 12 well-known funds, the tax demand is being made for full capital gains tax, which is 10% with backdated interest and up to 50% of the income. This is RADHIKA BAJORIA, founder of Radically Yours, and you're watching Radical Simplicity. In this episode, we speak to experts on what exactly went wrong with the funds and why has the income tax department filed demand notices. The government has denied treaty benefits to grandfathered PE and VC funds. What is the context of this? And the government told something else before 2017, that there will be protection for these PE and VC funds, and that's how they were grandfathered. But now they're going back on their own words and they have issued demand notices to such funds. So what is your view on that?
There was a famous Azadi Bachao Andolan case. There was a circular issued by the CBDT, which was the subject matter of that dispute. And, the sum and substance was that the circular said that if a Mauritius company has a tax residency certificate issued by the Mauritian authorities, then the Indian side ought to give benefit of the treaty and not look further into the manner in which the business is conducted. Now, that was upheld by the Supreme Court, but having said that, there were always situations in which the CBDT and through its officers used to, poke holes in the way the affairs of funds based in Mauritius, or for that matter, even other investors based in Mauritius, were conducted and were denying them the treaty benefits.
If you've set up a law that says, you are entitled to X benefit, you can't punish people for claiming that benefit. You can't eat your cake and have it too, right? Because you can't approbate and reprobate. If you say something and says, I want to attract investments into the country, these are the incentives that I'm offering you. If I invest and claim those incentives, you can't go back on your word and say, you know what, we're not going to give you the investments. Because that's inequitable to me. That's unfair to me. And the entire international investment climate is geared towards giving certainty to the investor.
So the scope of reassessment is basis fiscal evasion and treaty shopping, is it?
No, reassessment is a different can of worms compared to GAAR, treaty shopping and all of those other things. Okay, what has happened is that the reassessment provisions have undergone changes in the last 20 years, and in the last couple of years, they've been completely revamped. Okay, up to March 31st, 2021, the law for reassessment was that if the assessing officer has a reason to believe that income has escaped assessment, then he has to record those reasons, give a notice to the assessee, ask him to provide an explanation. And if he is not satisfied with those explanations, he can go ahead and undertake a reassessment of income. What has happened is some assessing officer realized that, I have not assessed people who came from treaty jurisdictions. Okay? They have claimed a capital gains tax exemption. And the reason that some assessing officer realized this is because of an AAR that came out in 2020, which was the Tiger Global AAR. This is the Flipkart case. What happened is, if you're aware, Tiger Global, one of the investors in Flipkart, sold its stake in the Singapore company which held shares of Flipkart. That company which held the shares of the Singapore entity was a Mauritius tax resident. It claimed exemption from the indirect transfer regulations or the indirect transfer tax under the India-Mauritius tax treaty. It filed for a withholding tax certificate. It was denied. The company went and filed an AAR. The AAR then ruled that Tiger Global was trying to evade tax because the place of effective management of Tiger Global was not really in Mauritius. It looked at the substance requirements in Mauritius for Tiger Global and said that, all of this is based in USA. There are directors in the US who are taking all of these decisions, and therefore they are not eligible to claim the tax treaty benefits. The case is still sub judice, but now the tax officer realized that, courts are willing to take such a view, even though it's an AAR which is applicable only to the facts of that particular case. It is not a high court case. And now they've gone ahead and tried to, open this matter up in cases where assessments have not happened. In cases where the treaty has already been examined, the limit for reassessment was up to 31st March 2021. It was 4 years. Where there is no assessment that has happened, they could have opened it up to 6 subsequent assessment years, which is 7 years from the end of the year in which the transaction took place. So that gives us that if you've taken a transaction in financial year 13-14, you could have received a notice up to 31st March 2021, and the order should have been passed by 31st March 2022.
While obviously in all fund exits, there were extensive negotiations on tax indemnities, tax escrow, tax insurance, and there were legal opinions on tax withholding. But while all of this happened, there was an underlying faith, and that faith was created basis multiple discussions with the government. It was discussed that the structures prior to 2017, which have been specifically grandfathered, will not be opened up.
What changed in 2017 was the renegotiation of the treaty itself. And this was not just the Mauritius treaty, it was, for example, also the Singapore treaty. And interestingly, the government, instead of just saying that, the capital gains exemption is no longer available, had agreed specifically with the countries on the other side that all investments made up to 31st March 2017 would be what we all commonly call the grandfathered, which means that the benefits under the tax treaty of giving them the capital gains exemption would continue.
What turned the tables was the extremity to which the entire Azadi Bachao Andolan principle was stretched. And the government argued that there was a case where there was no decision making, no substance, no form. It was a complete sham transaction where the Mauritius company was interposed just for the heck of it, and the US company was truly the decision maker. This truly gave the tax department shot in the arm to go after such matters, despite the fact that it was a settled provision after the Azadi Bachao Andolan.
I think having succeeded in that argument, that's what's causing them to go after more cases. So pretty much today, we also are aware, whether they are clients or just generally in the market, that almost every Mauritius investor is getting notices or has already got notices, questioning them and asking them very, very pointed questions on how the whole affairs of the fund are being conducted. Who are the directors? What are their capabilities? What are their qualifications? Who signed the term sheet? Where were the negotiations done? Who took certain decisions? Where was the bank account? When was it funded? When the exit proceeds came, how long were they sitting in a Mauritius account, or did they immediately go up? Who are the investors? What role do investors have? All pervasive sort of set of questions with, in my opinion, a single intent to demonstrate that there is no substance and no decision making in Mauritius, and then using that as a basis to deny the treaty exemption.
Let's have a look at the qualifying metric for establishing substance. Now, the substance requirement is different as per GAAR and as per DTAA. As per GAAR, you just have to establish that tax is just one of the reasons for you to invest in a particular jurisdiction. But in DTAA, the rules of the game are stricter. Under DTAA, which has multilateral instrument, also known as MLI, the principal purpose of a transaction shouldn't be to obtain a tax benefit at all. A few precautions that the funds can always take is that when they're investing through Mauritius, Singapore, or Cyprus, or any other jurisdiction, it should be ensured that the minutes of the meeting of the board meeting held in that particular jurisdiction is duly recorded. And while tax can be one of the reasons to invest into a particular jurisdiction, it shouldn't be the only reason. Other non-tax reasons should be established, such as the jurisdiction has great cultural ties with India, has a bilateral treaty, and has a flexible corporate law regime.
What GAAR does is say that if you have entered into an abusive transaction, then we will tax you for the gains that come through because of that transaction. Judicial GAAR was always there. Okay? When we say that, people realize that GAAR was there, not there, we should understand that there was always a judicial GAAR in India. Okay, there were various cases that the government was fighting up to the Supreme Court. There was McDowell's, there was Ramsey, those principles were there where the courts had established that if you try to abuse the provisions or the benefits of the Income Tax Act and the treaties, then we will go after you. So the government anyways had that particular avenue available to it. People knew that even at that point, they should not and could not have done tax evasion.
Now, when GAAR was introduced in 2017, there was already a fear that the tax department might open up the past cases because the language of GAAR was so wide and subjective that it could be applied in any irrational way by the tax department. And by nature, Indian tax authorities are anyways known to be very aggressive.
So in my view, I think under law, any law must always be read with a sort of purposive interpretation, and there cannot be a gross abuse of that law. I think it's not correct for the government, at least at the level and in the way in which it's doing, to make such kind of blanket and sort of far-reaching inquiries. The whole purpose of treaties is to sort of give certain bilateral comfort.
Right.
Talking about investors coming into another country, doing business here, and once they rely on a particular treaty which has a particular language and a set of provisions, if those then sort of get challenged by overlaying a long list of substance conditions which are not apparent or not known to an investor, then it creates a burden that is sort of unfair to a large extent. So again, in my opinion, having given the grandfathering provisions, the revenue should not be going this far unless they have some evidence to show that there is something in the nature of a fraud, or there is some misrepresentation, but not in the manner in which they're doing it across the board, even for genuine Mauritian investors.
Can the diplomatic arrangements, which includes the DTAA, which is Double Taxation Avoidance Agreement, be overridden by tax department? Because if Mauritius wasn't one of the treaty jurisdictions and there was no tax exemptions, funds could have probably not invested in India, because the entire investment thesis was based upon the fact that a fund will only come to India to save taxes, and that is how the money was flowing into India. And of course, whenever a fund invested, tax was not the only contribution that they made to the economy. There was much more that the fund's money did in the country. Why are only selective funds chosen for this by the government? I mean, there are many funds which must have violated this treaty, but why government is only going behind some selective funds? What are they trying to prove?
Historically, these routes have been used by very large institutional investors, pension funds. Some of the fund houses that may not have actual substance, but who just tied up with, say, administrators or third parties. They may be the ones that the government is now going after, because they think the likelihood of establishing a successful case is higher. But obviously, the degree of success is going to be much lower with an institutional player, a large institutional player. If you're looking at someone like Tiger or Goldman Sachs or something like that, and these are seasoned operators. They know exactly what the law requires, and they actually have substantial operations in the jurisdictions that they operate from. So it's a question of picking and choosing the right target for the government to see who they can recover money from.
Do you think that the government, going back on its word, might also significantly affect the incoming investors coming in GIFT City? Because right now we have 10-year tax holiday for the investors there, but that might also just change one single day if the government thinks that they have not collected enough tax.
Yeah, the government says one thing today, but maybe 10 years from now, they'll find out that their understanding of the conditions is not in line with your understanding of the conditions. So you might set up in GIFT City thinking you've satisfied the conditions for claiming those benefits, but in the future, if the government says, what, we don't think you have, that creates an issue, right? It creates an issue where, retrospectively your benefits might be disallowed. And that is a challenge, of course, that investors will have to reckon, from an ongoing basis.
The Income Tax Department has also sought an explanation for irregularities in calculating income from 2013 to 2016.
So some of our fund, Mauritius-based funds especially, what they used to happen is that before 1st April 2017, they used to have treaty benefit for capital gains. So the year they used to have losses, they used to carry forward those losses under the Income Tax Act. The year they used to have net gains, capital gains, they used to take exemption under the treaty, but carry forward the losses of earlier years to next year, where they were a positive income. They never used to set up old losses against. They used to, carry forward the entire earlier year losses to next year, and with the hope that one day the treaty will change and they will be able to utilize, which happened. 1st April 17 it happened. So of say 2015-16 losses, were adjusted against the gains of, say, financial year 18-19, 19-20 kind of a thing. So government or the tax authorities said ki you can't do that. You can't have best of both the worlds, claiming exemption in a positive year and carry forwarding the losses, in the loss year. You have to be consistent, and you can't, take best of both the worlds under the Act as well as treaty.
Now that the law is already unsettled, it will be very painful for the funds industry because procuring such old documents become difficult, plus the litigation costs involved in such processes are very high. Also, the GP is answerable to their LPs to give them back their money, but in such circumstances, giving back the money becomes difficult, and it is in such cases that the LP give back provision comes as a rescue. Why has the tax department opened up the past cases? Well, that remains to be seen, but one point that you shouldn't forget is that the compensation of the tax officer in India is dependent on the claims they make. In 2012, Arun Jaitley in the BJP government had called the Vodafone case to be a retrograde move and equated it with tax terrorism. If opening up pre-2017 cases on flimsy grounds is not tax terrorism, then what else could it be?